Excited Utterance, the Evidence and Proof Podcast, Episode 172, Laura Savarese, Children and the Making of Modern Evidence Law. Welcome to Excited Utterance. I'm your host, Ed Cheng from Vanderbilt Law School. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence. We bring virtual workshops to you throughout the academic year. This week, our guest is Laura Savarese. Laura is an assistant professor of law at Michigan State University College of Law. Laura is a legal historian who studies the relationship between families and the state. She teaches family law and civil procedure. Our podcast this week features Laura's article, Witnesses for the State, Children and the Making of Modern Evidence Law. It was published last year in the Law and History Review. In it, Laura tells the story of how the law of evidence changed in the late 19th century to become more accommodating of child witnesses. Under the common law, child witnesses were presumed incompetent, a rule that was consistent with both the historical preference for witness disqualification rules and an emphasis on the oath. Laura shows, though, that with the Progressive era's child protection statutes, the law could no longer exclude child witnesses with such a broad brush. After all, if you want to prosecute crimes against children, then you need the testimony of child witnesses. So what followed was a period which some would argue extends to today, in which the law of evidence has struggled with the problem of child witnesses. On the one hand, we need children to testify. On the other hand, we worry about whether children are sufficiently reliable witnesses to base our legal conclusions, and we worry about further traumatizing child victims by making them testify in a strange and foreign environment that is the courtroom. My conversation with Laura explores these issues and much more. Laura, delighted to have you on Excited Utterance. Welcome.
Thank you so much for having me.
Your article is, of course, a history of child witnesses and how they relate to the law of evidence. To start our discussion, let me have you set the stage. So, what was the common law treatment of child witnesses going back to the 18th or early 19th century and before the transition period that you talk about in your article?
Yeah, great question. And I should say that I don't claim specific expertise on the evidence law history broadly. I'm a legal historian of family law and children's law primarily, but became interested in this topic because I wanted to understand how were children speaking in all these family law and child protection cases that we might take for granted today, but wasn't taken for granted in the 19th century, which, as you said, the prevailing system of exclusion of the 18th century common law, or rather the rules typically excluded children under 10 or under 14, especially in criminal cases. And although there wasn't, under the English rule, a precise age at which children were automatically or absolutely barred from testifying, they weren't presumed competent to take the oath. And therefore, their ability to testify would depend on the judge's examination of their understanding of the nature and effect of the oath, which usually meant a pretty stringent test of competency, an understanding of the religious sanction implied in an oath. And so in the state that I look at in particular, New York, by the early 19th century, the state had codified that restrictive common law rule and required courts to examine their competency to testify before they could give evidence. So basically, to recap, what were the restrictions on children's testimony in this period? It was this presumption that infants, i.e. children under 10 or 14, were not competent to testify, and therefore their ability to testify depended on the judge's assessment of their capacity and knowledge of the oath. And furthermore, there wasn't at that time a provision permitting courts to dispense with the oath and allow younger children to testify unsworn.
And that account, I think, is of a piece with the way that most people think about early America and evidence rules, that you have these witness competency rules that were a big part of the law of evidence. And then we have this understanding that these competency rules started to disappear in the late 19th century and were replaced by a focus on cross-examination and a greater deference to juries, that juries could figure out whether or not the witnesses were any good, and we didn't have to exclude the witnesses from consideration entirely. But you argue that this standard story, this move to cross-examination and deference to juries, didn't quite work in the case of children. Why not?
Yeah, that's exactly right. Part of why I got interested in this is that legal scholars and historians have this general theory for the demise of common law witness disqualification rules over the 19th century, where these 18th century rules of exclusion, qualifying witnesses based on their interest in the case, based on lack of religious belief, and so on, they were replaced by this new reliance on juries' credibility judgments and by lawyers' cross-examination of witnesses. And I do think that provides a pretty persuasive account for legal change in the case of adult witnesses. But the erosion of these restrictions on children's testimony that my article describes, I thought required maybe an additional or alternative explanation. And that's because cross-examination has always been understood as less effective in getting the truth from children. And there's always been some special skepticism about the jury's ability to assess children's credibility. And so I thought that was a little bit of a puzzle. The evidence law scholarship, and also maybe a story that was missing from the historical legal scholarship on children's law, which focuses a lot on the creation of new substantive legal protections for childhood, child abuse and neglect laws, child labor laws, and so on, but doesn't necessarily examine some subtle but still important changes in evidence law and procedure and practice that would allow children to actually give evidence in those kinds of cases. So I hope that also explains why I was interested in this question to begin with, and where I thought we didn't maybe have a complete answer from existing evidence law and children's law scholarship.
Right. So the alternative story that you tell is that the demise of these child incompetency rules was in large part due to the emergence of these child protection statutes in a variety of different spaces, and that it is those protection statutes that led to evidentiary change. So, why did those statutes lead to evidentiary change, and what was driving this process?
Exactly. Yeah. So if I said we might need a more complete explanation other than newfound faith in cross-examination and juries, my hypothesis was that impetus for reform, for liberalizing the rules around children's evidence, came out of the state's need for young children's testimony in order to enforce these newly codified offenses against children, and in particular, a new set of sexual crimes against children. And to sort of test that hypothesis, I looked at a series of legal changes that eased the admission of children's testimony in progressive era New York, which was a state that was on the cutting edge of the child protection movement. It had a very powerful Society for the Prevention of Cruelty to Children, or SPCC, that was an important player in this story, that was very motivated to not just to prosecute crimes against children using children's evidence, but also to lobby for some evidence law reforms to make it easier to secure that kind of evidence.
I find the story kind of fascinating. As I understand it, Most of this change in the evidentiary space, obviously, this is true
Mhm.
in the substantive child protection space as well, but most of the change in the evidentiary space came from the legislature. So the legislature passes the child protection statutes, and then they say, but we need the evidence from the children, so we're going to mess with the evidentiary rules as well. But evidence is usually a set of judicial rules. They're really about how we prove things in court. And what you have is the legislature stepping in and changing a set of judicial rules in service of its own broader legislative policy. And I would have expected something of a turf battle. So, did the courts resist this reform at all?
Interesting. I don't have evidence that the court resisted the liberalization to the extent maybe I can get into some of the details of the changes to make it more concrete. If anything, I think what I found was that some evidence that judges seized on their newfound power to admit children's evidence. Yet at the same time, some of these anxieties about the reliability of children's testimony, about the trauma that children might suffer from testifying in court don't go away. And there's also some evidence of judges being worried about that. Just to give an example, so one of the legislative changes that you're talking about that was lobbied for by the New York Society for Prevention of Cruelty to Children is this 1892 law that gives courts discretion to allow younger children to testify unsworn in criminal cases. Did also impose a corroboration requirement on that. But this was a significant change. It allows prosecutions that likely just wouldn't have happened before, including an example of a statutory rape case with which I begin the article. And I find examples of judges admitting children's unsworn evidence in these kinds of cases. And in addition, I guess the other practice that I track is not legislative, but is more in the realm of judicial practice, is evolution in how judges assess children's competency to testify. So this again is that big screening device that I was talking about before, the examination of children's competency to testify under oath. So I talked about the route for giving unsworn testimony, but this is the route for giving sworn testimony, which today plenty of states have done away with, but plenty of states also still retain. And so I also track some changes that suggest that reformers in this period are pushing judges to adopt a somewhat more flexible test of children's capacity to testify that focuses less on their religious belief and understanding and more about their sort of cognitive abilities and understanding of a basic moral duty to tell the truth, something that looks more like the modern competency standard.
Yeah, it's interesting. There's a waning, it appears, across the board about the necessity of having religious belief. So you actually even have the abolition of the requirement of religious belief generally. And then you even have Wigmore that you mentioned in your article saying that rather than focusing on oath exclusively, that the jury needs to think more about the ability of the child to observe and narrate and all of the usual testimonial capacities that we think about when we think about witnesses today. So I wanted to sort of push on a couple of other aspects of these reforms that you mentioned. One was about the process of bringing children into court. So, in modern child witness cases, I think judges frequently worry about further traumatizing children in this really foreign and intimidating environment. Was this cost of this liberalizing stance on child testimony a worry of judges at the time as well?
Yes, and I think one piece of evidence for that, again, is a little bit in how judges seem to be conducting the competency inquiry. Here also it might be relevant to note this is the birth of the juvenile court, the turn of the 20th century, which was designed with the idea that a more sort of informal procedure would be best for both trying cases of children accused of crimes, but also cases of child abuse and neglect. And the idea being that children's are going to be very important sources of information in those cases, and judges should adopt a sort of more friendly and informal conversational style. And I think judges in adult criminal courts also seem to adapt their approach to the competency inquiry to that understanding of child development, of children's special vulnerability, and the special anxieties that children might face in the courtroom. So it seems to have influenced them in that way. The other way that we see this appear is perhaps a little bit of a darker part of the story that I could talk about, which is the third kind of reform that you see in this period is the revival of material witness detention in cases where the state needed children's evidence to make their case, particularly in cases of sexual violence against children and primarily girls in this period. So it's quite kind of striking to me that this period where we see sort of liberalization of evidence law for children is also accompanied by this program of sequestering children, removing them from home, but with the stated rationale that this is going to protect children from manipulation by adults. And it's also going to protect children in the sense that it's going to save them from the peril of false swearing by ensuring that their testimony remains intact and more reliable. So this is one of the maybe a little bit more perverse results of this push to bring in more children's evidence into court.
And one thing that was a little bit unclear to me, so this tension of material child witness practice that showed up, which surely was concerning, this wasn't just in those cases where the child was removed from the home because the home might be actually dangerous to the child. It was actually for evidentiary purposes, is what I'm hearing from you.
Exactly. Yeah. It so happened that I think one of the statutory provisions that courts relied on in ordering children detained as witnesses was in the same provision of law that provided other grounds in which children could be removed from home in cases of, abuse and neglect. But no, this was a standalone provision that contemplated detaining children in the New York Society for Prevention of Cruelty to Children had a building for housing children as material witnesses. And some of these children were also housed temporarily in other custodial institutions for children. These were so-called orphan asylums, juvenile reformatories, and the like. And again, the rationale was that this would be a way of accommodating or addressing this anxiety about the reliability risks of children's testimony and ensuring that the state would be able to get the evidence that it needed, particularly in these sexual offense cases.
There's this deep irony there that in the zeal to protect children in this way, the legal system, I think, ends up harming them in other ways by effectively pulling them away from their families and putting them or secluding them in a place that's foreign and strange. It actually also reminds me a bit of a broader tension, which I think is a related broader tension to this that you discuss in the paper, which is that in order to litigate these statutes, the legal system needed to treat children more like adults. In order to get the evidence from them, the legal system had to treat the children more like adults. But at the same time, the whole point of these child protection statutes was to, in a way, insulate childhood from the adult world. Is this tension irresolvable? Like, is this something that is just inherent in the project, or was there a way to maybe resolve this?
Absolutely. So I think you're right then in a broader sense, what we're seeing is the origins of this tension that persists in the law between, on the one hand, the state's interest in child protection, and on the other hand, our commitment to an adversarial truth-seeking process. And that's a process in which, children and other vulnerable people do not always fare so well. And I don't claim to have a resolution to this tension. I do think that history can be helpful in illuminating this kind of point of friction between rational truth seeking on the one hand and our commitment to child protection by way of criminal law enforcement. And I also would say that what I'm hoping to show is a recurring dynamic in which the state's need for children's evidence has spurred these waves of legal and procedural reform out resolving these anxieties and these tensions. And that's not to say that evidence law is dictated purely by politics or the state's policy and law enforcement goals. Again, just for us be honest about the fact that evidence law is only partially independent from substantive law. Even as it has its own set of logics, it's also shaped by policy goals and demands of the state.
Final question for you. What's next for you? I know that, as you mentioned at the beginning of the interview, your work is primarily in family law. Any other evidentiary projects in the works?
Not strictly evidentiary projects. I'm interested in this broader question of child welfare and how the state fulfills its obligation to children. And in that regard, I think we need to not look only at the content of substantive law. We also have to scrutinize, the systems and processes by which the state enforces those laws. And so one of the projects that I have right now is kind of examining a different aspect or a different legacy of the child protection movement that tracks the legal rights and protections for the child-parent relationship that are forged in large part through a pushback to what I show in this paper, which is the growing reach of the state over family life. And so I make the argument that we can find the origins of a right to family integrity and constitutional protections for the parent-child relationship, in particular parents' rights to a notice and opportunity to be heard before their children are removed from them. We can find that in a set of legal challenges to the laws by which the state removed children from home and placed them in some of these institutions for children that are sort of the forerunners of our modern child welfare and juvenile justice agencies. And so I do think, though, that the evidence piece, it might seem sort of like a surprising place to look for a family law historian, but I actually think that it can tell us a lot about how the dilemmas that we see today are legacies of this 19th century child protection movement, and helps us think critically about whether that has on the whole tended to benefit children or whether these legal changes that have allowed more children to be heard in court come with certain costs that we ought to scrutinize. In that sense, I actually think evidence law is a super interesting place to look for people who are studying family regulation today.
Well, I think I can say for most of the people in the evidence space, we think evidence is everywhere. So this is not odd at all. Part of me actually thought immediately of the parent-child privilege and the debates about that today. You certainly see family law type issues in the evidence space. Well, Laura, thanks for a fascinating discussion on child witnesses and how their treatment has evolved over time. Great having you on the show.
Thank you so much.
Laura's paper offers an important perspective on the momentous shift that occurred in evidence law in the late 19th century. The common law prior to that featured a whole host of witness disqualification rules. One of the major ways that we regulated evidence then was by focusing on the source of the evidence and not the evidence itself. So the law excluded witnesses, not just specific pieces of evidence. That, of course, all changed. The disqualification rules were replaced by the system that we largely have today, which emphasizes impeachment through cross-examination, trust in the jury, and some surrogate rules for the previous disqualifications. I suspect all of us would say that this was for the better, but we have had trouble fully letting go, and the legal system has suffered plenty of growing pains along the way. For example, the spousal testimonial privilege fits oddly as a privilege because it's really a competency rule, and it has died only a slow death. Rule 609, which uses character evidence to replace the former felon disqualification rule, that has come under serious attack in recent years. As Laura points out in the paper, we're still struggling with the abolition of the child incompetency rule. Child witnesses remain one of the most challenging evidentiary problems today. How we handle child witnesses, both to protect them from unnecessary trauma and to protect defendants from unreliable evidence, remains controversial and unresolved. I wanted to emphasize one additional aspect of Laura's story that I found rather intriguing. We often think of evidence and substantive law as largely independent. Evidence and proof figure out the facts. Substantive law figures out what to do with those facts. But the story of child witnesses shows that this separation is far from clean. To accomplish the legislative goal of child protection, the evidentiary rules governing children had to adapt. But that raises a deeper separation of powers problem. Is it a good idea to allow the legislature to manipulate the evidentiary rules, which are essentially a judicial function, in order to serve the legislature's policy goals? When is that interference, if ever, legitimate? We're obviously not going to resolve such deep questions in a single podcast episode. They're difficult and old puzzles, but they are certainly something worth thinking about. Support for Excited Utterance is generously provided by Vanderbilt Law School's Branstetter Litigation and Dispute Resolution Program, as well as the Texas A&M University School of Law. The associate producer is Alex Nunn, and the production editor is Anna Rude Morella. Additional production assistance is provided by Lizzie Herrera, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Ed Chang, and I hope you'll join us again next time when we take on another new work in the world of evidence and proof.